Good morning, Your Honors. Todd Allen on behalf of the appellant. Your Honors, I would like to reserve approximately 5 minutes at the end for rebuttal. We're here on the entry of a summary judgment in favor of the appellee. Your Honors, to give you a brief background on the facts of this case, Anil Masters owns a real property in the Appellee's Condominium Association. My client leased that property for him for a period of time and later submitted an application to be approved by the association to actually lease the property. For a number of reasons, the association rejected that.
It was rejected initially, as I understand it, because there was a problem with the pet issue, and there was a problem because the owner was not up to snuff on his assessments. So those are the two main reasons. Is that right?
That's correct. That's why.
Is there anything in the record that was filed in response to the summary judgment or otherwise that addresses the assessment issue?
Well, the assessment issue was later was taken care of long before the lawsuit was ever filed.
So there's nothing in our record about it?
No, because the assessment issue was eventually taken care of by Mr. Masters long before.
But is there anything in the record that tells us that?
No, Your Honor. No, there's nothing in the record saying that that issue was resolved. The second issue, the pet issue, was later resolved by the occupants, and the pet was eventually removed.
As I understand it, the allegation is that this the ban on pets was selectively enforced. That's your position?
Well, yes, the pet
that the Gronemans were singled out, and
that is one of
had presumably dogs, cats, or whatever, and they weren't subject to any problems.
Yes, Your Honor, that is correct. The allegation was in the first affirmative defense that the pet policy and also the approval process for a new owner was selectively enforced.
But when you got to the summary judgment hearing, was there anything filed in support of that, such as affidavits from Mrs. Smith saying, "Hey, I've got 3 Afghans and nobody's given me any problems about it," or it's just something that was put in a pleading and that was it?
Well, no, Your Honor. In response to our affirmative defense, as you know, the burden doesn't carry to me to prove my affirmative defense until the appellee has the burden to either establish the legal insufficiency or to refute it by affidavit. And you'll notice in the third point that I raised in my brief that that wasn't done. In fact,
let's walk through this a little bit, because
sure.
I'm not certain how the assessments might have tied into the status of the pleadings at the summary judgment hearing,
okay.
And then also when your clients were not approved to purchase, because you said a few minutes ago that the assessments were actually taken care of.
That's correct.
When was that?
It was long before the lawsuit was ever filed by the association. It was something that they used in the complaint to eventually to support their denial of Mr. Groneman at the time that they filed the lawsuit. That's what they used to support it. You'll find out later in the facts, Your Honor, that Mr. Groneman and Mr. Masters entered into agreement where they transferred a portion of the property to Mr. Groneman to actually own by virtue of a quitclaim deed. And so when after that took place and the assessments were taken care of, that's when the association filed the lawsuit in a 3-count complaint to declare that the first count to declare that the deeds were invalid. The second was to evict Mr. Groneman, and the third was to get a permanent injunction to prevent Mr. Groneman from ever returning to the property.
And the contention was the deeds were invalid for 2 primary reasons: failure to pay assessments, so they didn't get approval, and the pet policy. And I don't remember, was the pet policy a basis to not give approval?
No, in fact, the only basis the association alleges for support of denying the transfer of the property was that they didn't follow the formal procedures.
The pet policy and the assessments had to do with the lease.
Exactly. And so
that's the reason the lease wasn't approved, right?
That's it, exactly. And after the lease was denied, Mr. Groneman and Mr. Masters entered into agreement where a portion of ownership of the unit was eventually transferred to Mr. Groneman. And then after that was transferred, that's when the association filed the lawsuit.
But transfers and sales have to be approved by the board.
Yes, in section 13.1 of the declaration. However, in our first affirmative defense, we allege that was selectively enforced. And part of the reason why that was alleged is that according to the documents, the declaration of condominium, the association is required to record a certificate of approval anytime that it approves a transfer. In my research, in preparing the affirmative defense, I went to the Collier County Public Records to look for these certificate approvals. And I didn't find many. I found very few, but I found many deed transfers that were done, and I couldn't find a coordinating certificate of approval. So that's why that issue was raised.
Does it have to be filed in the public records, or under the bylaws or the condo documents, it is a record of the board?
It is it's an actual certificate that is supposed to be recorded in the public records. And that's not something that was ever done, and that leads me to one of the first issues that I cite in my brief, is that we had outstanding discovery at the time that the summary judgment was entered. And some of this discovery was directly relevant to that first affirmative defense. We requested for production all communication between the appellees, that board of directors, regarding the appellant, to determine if there was any bias, if there was any, we've got to get these people out, they're dragged on society in that community. The second was all certificates of...
Let's talk about the request to produce for a minute.
Mm-hmm.
Your client filed for summary judgment on May the 1st.
Yes, Your Honor.
All right? So May goes by, June goes by, July goes by. At the end of July, your client notices the motion for hearing.
Correct.
Right? For August the 19th.
Correct.
The request for discovery goes out on August the 8th.
I believe that's correct, Your Honor.
So that's 11 days before the hearing.
Well,
right?
Yes, Your Honor.
Stay with me.
Yes, Your Honor.
So a number of issues here. First of all, the discovery isn't even due, but your client didn't file any kind of motion to shorten the time frame to respond. Your client didn't file any motion to compel. Your client didn't file a motion to continue the hearing. Your client had filed for the summary judgment, noticed the summary judgment, went forward on the summary judgment, well knowing that the discovery wasn't due, and you did nothing about it.
Filed our motion for summary judgment to hear our motion for summary judgment. But, Your Honor, I did request...
Your client noticed actually both motions.
And I do acknowledge
you guys drove the whole train without...
And the reason...
apparently the goods in the back that you say you needed.
And the reason that was done, Your Honor, was to bring this up to the trial court that there was outstanding discovery.
Did anything get filed?
I'm sorry?
There was no motion to compel, though, was
No,
there?
but at the hearing, Your Honor, I asked for additional time.
Verbally, you went to the hearing and at that point raised it verbally for the first time with no at least you say you did, but the other problem is we have no transcript.
But and I also raised it again in the motion for rehearing, Your Honor. That issue was well before the court.
Is there a transcript of that?
No, the judge denied it without
So how
hearing.
do we review this?
That's a good question, Your Honor, but I don't think that the timing is necessarily an issue. I mean, this case is a 2013 case. We're not talking about a long time. I mean, the case was filed and
well,
taken to...
Well, the timing's an issue insofar as your client didn't take any steps to get what they needed, and it wasn't even due at the time that you went forward on a hearing that you requested.
Well, and I respectfully disagree, Your Honor. At that time, we were conducting discovery. We had noticed, we'd actually taken the deposition of the property, or of the board of directors president.
I disagree with.
That we weren't actively trying to get this information.
I said the discovery wasn't due at the time when you went forward on the hearing that you requested.
And I wasn't trying to shorten the time period for them to respond, Your Honor. At the hearing, I asked the judge in response to their motion for summary judgment, the judge, I had these outstanding issues to create a question of fact on whether or not they're entitled to a judgment as a matter of law.
But you cross-noticed?
And I acknowledge that.
You set both motions.
And I acknowledge that, Your Honor, that was a mistake in our office, because it's generally practice in my office to do that. But in this case, it somehow slipped through and I wasn't able to correct it before it got there. And that's not something I would have done in this case when I had outstanding discovery. I willingly acknowledge that was a mistake on my office. And the other argument that we raised in our brief is that the trial court didn't give me the opportunity to amend our answer an affirmative defense. And after further review, Your Honors, I would like to withdraw that argument because I think that the trial court actually did rule correctly on that issue. So the only issues that I think that the trial court erred on was the first issue of the discovery issue, and then the second issue, and probably the more important issue, is the failure to address any of these affirmative defenses in the summary judgment motion of the appellees, and also the failure to address any of these issues in any affidavits. So what we're talking about here is a series of affirmative defenses that if appellee came to the motions for summary judgment hearing and tried to convince the court that these were insufficient as a matter of law, that's arguing outside the scope of his pleadings. It should have been, it's absolutely improper at the time to do that.
Well, here's another practical problem that you'll probably do the next time, but without a transcript, all we're doing is deciding whether you're telling us the truth or he is or what, because nobody knows what happened, and we've got all sorts of cases out there saying we don't do that sort of thing. We got to see it in writing.
I completely agree and understand, Your Honor. Best practice is to have a court reporter so this doesn't happen. In this case, for reasons I can't explain, it didn't happen. But these are the reasons why we feel, I mean, the case law specifically in this district in regards to affirmative defenses is that if they're not addressed in the motion or addressed in an affidavit, the legal sufficiency of which is not questioned or factually refuted, then summary judgment simply is improper at that time.
But as Judge Black is focusing on, we can't tell what was said, what was conceded, what remained an issue, what doesn't. It creates a review problem for us.
Well, I understand why you would take that position that creates a review problem, Your Honor, but if you look at the case law and specifically look at the Tunwill case, the Coral Wood Page case.
Well, let me take the extreme example. Suppose your opponent gets up here and says, well, on the day of the summary judgment hearing, opposing counsel said, Judge, we're not relying on any of our affirmative defenses.
Well, I don't think that he could
withdraw them all.
I don't think he could make that statement, Your Honor, when after summary judgment.
We don't know.
Well, but Your Honor, I think you can infer from the record that didn't happen when I filed a motion for rehearing and addressed those issues shortly after judgment was entered. I mean, I had a short time period under the rules of civil procedure to file a motion for rehearing, so it would be, I don't think counsel for the appellate can come up and make that argument when I raised that same issue in a motion for rehearing and pointed to the trial court the exact law that this district has ruled that you can't enter summary judgment when none of these affirmative defenses have relied or have been factually refuted or shown the legal insufficiency of. I think what you'll hear from the appellee is that, and certainly what they argue in their reply or response brief, is that the judge found independent grounds under the PET section to do what it did. Well, even if it did, it still didn't address whether or not the transfer of the property was selectively, that restriction of 13.1 of the declaration was selectively enforced. I mean, because we're dealing with an eviction issue, okay? They were, the lease was eventually denied, but now the property was transferred to Mr. Groman. Now we're dealing with an ownership issue, and the veracity of Section 13.1, if that section is not specifically
Did you raise selective, maybe I'm forgetting this, did you raise selective enforcement as to approval or rejection of the deeds?
I did in my first affirmative defense, Your Honor. The first affirmative defense is kind of an all-encompassing. It addresses the selective enforcement of the PET policy. It also addresses the selective enforcement of Section 13.1, which is the declarations section that says that the association has to approve any transfer of record.
But the briefing here suggests to me that the selective enforcement relates exclusively to the dogs, and the other issue being the delinquent assessments. And it's not clear to me in the briefs that the issue of selective enforcement of the certificate of transfer was preserved below or is argued here.
Well, it was specifically addressed in my first, in the initial brief, Your Honor, in the third point. It was addressed at the lower court erred by entering judgment because the defendant of selective enforcement was never addressed. And if you look into the section B of the third point on page 9 of my brief, I specifically talk about that the decision to dispose of this entire action on the failure to follow the application process in section 13 was made without any evidence or any facts or issues resolved, refuting that first affirmative defense of selective enforcement.
Are you contending that the challenge to the deed is the sentence in your first affirmative defense? Finally, defendants have reason to believe that the association has selectively enforced section 13.1 of the declaration?
Yes, Your Honor.
Without indicating what it is in section 13.1?
Well, section 13.1 in the declaration is the actual application approval process.
Then the next sentence says, therefore, association is stopped from maintaining any purported causes of action contained herein due to its selective enforcement of the standards governing pet ownership in this community.
And I understand, Your Honor, it was inartfully drafted, but I think I raised and I certainly put the other side on notice that we were questioning the ability or the selective enforcement of all of those issues.
Any factual allegation anywhere in your defenses that say they messed up in relation to the transfer? Is that it? The references to
no, Your Honor.
13.1?
No, Your Honor. There's a number. In fact, my second affirmative defense, the defense of estoppel, specifically addresses that counsel, Mr. Masters, provided the deeds to the counsel for the association, and so we believed or we asserted that you can't deny the application because they're saying the application process was never approved when association had notice of the transfer and had an opportunity to reject it and never did.
Your second affirmative defense is that the association was given copies of the deeds.
Mm-hmm.
They didn't reject the transfer according to section 13.2 of the declaration.
Correct. Section 13.1 of the declaration says that they have 15 days to reject the transfer after receiving the notice of the transfer, and no rejection was ever received by my office or by previous counsel for Mr. Masters.
And your contention is they did not submit anything in opposition to your summary judgment to address that?
That's correct. Well, and nothing in response to the affirmative defenses that I raised to their complaint. So when they moved for summary judgment, the burden was on them to either establish legal insufficiency or to factually refute the affirmative defenses, and you don't find that.
Because we've had a lot of questions.
Okay.
So if you want to reserve the 5 minutes, you'll need to.
Thank you, Your Honors.
Thank you.
Thank you, Your Honor. Conrad Welcome on behalf of the Appellate Castella Tebron. As opposing counsel has stated, this case really revolves around the issues of selective enforcement and outstanding discovery. Perhaps we should step back and look at the two larger issues, which is, because this will be determined looking at these other issues, whether there was a valid lease and whether the deeds were effective in transferring title. The first question, whether there was a valid lease, it was clear from the court record and unopposed that that Masters was behind on his association dues. It is clear from the condominium documents that the association has the authority to deny somebody based on the fact that they are behind on their association dues, which they were at the time.
How does this work? Let's assume, and it's not on our record, let's assume that delinquency is cured. Do you have to file a new application for lease?
Yes, Your Honor.
So you
he was denied. So there was an application. The association made a determination. They denied it. So that lease application is done. If he wants to reapply, he can reapply. So the lease is done, and he no longer had possession.
There's no indication that the assessment deficiency was cured before or after the denial of the lease application?
It was not cured prior to the lease application.
I mean, is there anything in the record that...
Yes, there is an affidavit that was submitted by the property manager and by prior counsel stating that there was outstanding assessments due.
At the time the lease application was reviewed and rejected?
Yes, Your Honor.
I didn't see anything in the record disputing that. that the assessments were outstanding at the time that the lease application was filed. I didn't see.
I don't think they have disputed that
I don't think that's
fact.
in dispute, is it?
No, Your Honor. You're correct. I do not believe that they're contesting to or that they're disputing the fact that the assessments were outstanding.
And the selective enforcement goes only to the pets.
That's my understanding, Your Honor. I agree with your assessment of that as well. However, under the case law, when we're looking at the selective enforcement, to be honest, we're trying to cloud the issue and look at these different transactions. The selective enforcement is meant to create an issue of fact. However, if the court has an independent ground to make a judgment on, which it is clear that they did based on the outstanding assessments, then we can disregard the selective enforcement because we would have the ability to deny regardless. And in any case, there was obviously no selective enforcement, and they haven't provided any evidence to support that. And there's also case law suggesting that you can't just say that there's an issue of fact. You need to actually produce some
Help me a little
proof.
bit with this, because in my mind, I somewhat conflated together the lease issue and the deed issue, the deed transfer issue. And I don't know that the record ever really reflects that the assessment deficiency was cured, but assume for the sake of argument that there's something to support that contention. When the transfer occurs, how does the assessment deficiency tie in to rejection of the transfer?
There was never a request to approve a transfer. The association documents require them to submit a proposed documents for approval, submit an application for approval for transfer of title, submit an application for this. When they failed to vacate the property, when Gronman failed to vacate the property after the termination of the lease, prior counsel sent an email to them saying, why are you still have a dog in the property and you're not supposed to be there? And then they ended up responding, oh, well, he's an owner, and they sent a copy of they sent an executed deed. They never asked for that deed to be approved, and actually the prior counsel responded to them saying this was never approved. So
now, let me ask you then, in terms of your client seeking summary judgment, was that addressed by affidavits or any evidence submitted to the trial court in support of summary judgment?
Yes, Your Honor.
And what was that?
And there were affidavits.
The opposing counsel saying that, as I understand his argument, that there was nothing provided by the association for summary judgment to address the lease transfer and then the selective enforcement component of that.
What we addressed by the affidavits where the lease transfer was denied based on outstanding dues.
Okay, so we'll get past that.
And then with the deeds, the affidavits addressed that there was never any request for approval, that the affidavit addressed that he never submitted an application for approval, that they sent executed deeds to us, which are required to have approval ahead of time. So the affidavit showed that they did not go through their approval process, approval was never sought, and approval was never obtained.
And then in response to that affidavit testimony, was there anything submitted by the occupants or the now new owners saying, in fact, we did submit it, here's our sworn testimony by affidavit that we followed the application process and the association improperly rejected it either by selective enforcement or they just didn't comply with their own procedures under 13.1?
No, Your Honor.
Okay.
You've got another gap, though, too, don't you? I mean, as I understand, Masters transferred his ownership interest to an LLC.
Yes, Your Honor.
And it's the LLC that transferred the interest to the Gronmans?
Yes, Your Honor.
And there was no approval process on either of those.
No, Your Honor.
Okay, so I got two gaps in the chain of title in terms of board approval.
Correct. So neither deed was. You're right. When you're submitting the second deed, neither deed was approved. Neither deed was submitted, and they did these basically as an artful way to circumvent an attempt to try to circumvent the association rules.
There's no claim in the record that there was. I think maybe I'm just parroting Judge Silverman, but it isn't even being claimed that they attempted to get approval. I didn't find anywhere where that was alleged.
No, Your Honor. Their only claim is that they submitted that they emailed a copy of an executed deed, which prior counsel actually said was not approved. And they're saying that by sending that email with that executed deed that that equates to approval because we didn't deny it. Well, in fact, that was denied when the attorney said that was not submitted for approval and was not approved. And then and there was never any approval that was actually sought for this. So.
Is your client's position that you never get to the selective enforcement issue until the time exists that they properly followed the requirements of the lease of the association documents in order to request approval? I mean, am I understanding that correctly? That's a bad question.
I think what your question is whether we can have a summary judgment, because selective enforcement can be considered a factual issue that could preclude summary judgment in certain instances.
If all three conditions are met. If the other conditions of the transfer are met, then you can talk about, well, why did we get denied?
Correct. Right, correct. But in this case, and as we have case law that says that, for example, basically, if there's, okay, sorry.
You've got two methods of selective enforcement, it seems. Is number one, the Gronemans submit an application to buy the property, and the board says no. When similarly situated people, they say yes. Or they did not submit an application. They just did the transfer with Masters or his LLC. But that happens all the time.
And those are void transfers if they don't comply with the association documents.
It seems that might be a theory, but where you have either an acquiescence or a ratification that these transfers are happening all the time without any input from the board. I'm just theorizing.
If there was something in the record indicating that other people didn't have to do that, then you'd have a problem.
Possibly, Your Honor.
But then I think your argument is, at least in the briefing, that if you would have said it this way, I think your intention would be that they didn't plead any of this. Their affirmative defense doesn't say it's selective enforcement for this reason or selective enforcement for that reason. I think what you argued was their claim of selective enforcement goes to the pet policy.
Exactly, Your Honor. And then with respect to the pet policy, that's where we have a completely independent ground to deny the lease. I agree with you that if there was maybe more with respect to the if there was evidence in the record as it relates to selectively enforcing the approval, that might be a different issue that we'd have to address, but that's not before the court right now.
The first affirmative defense, there is the one sentence thrown in there that says defendants have reason to believe the association has selectively enforced 13.1, but every other sentence of that paragraph talks about the pet policy. So I'm having a hard time saying, well, they've adequately raised the first affirmative defense, but that's something we'll ultimately have to decide. The second affirmative defense, which is titled estoppel, arguably might bring in the concept of selective enforcement. Can you address that, the second affirmative defense, and why that didn't adequately raise the issue? If it makes it easier, it's the estoppel defense that says Masters sent the association copies of the deeds referenced in the plaintiff's complaint, complying with the provisions of 13.1. Plaintiff did not reject the transfer. Therefore, according to 13.22, Groneman is partial owner.
Well, once again, pursuant to the record, they did not submit an application. They did not submit a request for transfer. They did not. They never actually even requested the transfer. They sent a copy of a deed.
So your position is the affidavit submitted on behalf of your client that said they didn't follow the required procedures, and therefore, I don't remember if the wording was void or voidable or ineffective, but I think your argument is the second affirmative defense was adequately refuted when your client says they didn't comply with the provisions to get it before the board.
Correct, and then further in the documents, it does say that failure to receive prior approval does make the transfer void. In addition, opposing counsel has also focused extensively on the outstanding discovery. As Your Honors have mentioned, it was requested after the motion for summary judgment. There is case law, Levitron, that says that 7 months, which was the same as this case, is late for them to be requesting this discovery. And then, in fact, if they did not request a continuance, they can't then come back and then complain that they didn't have enough time. So in addition, it was not even the property owner that actually requested the discovery. It was actually requested by the tenant, and as the tenant, that he's a non-owner and he does not even have standing to necessarily request those items. We won't address the affirmative defenses, failure to amend, and ultimately, the final point is, as we said before, with the discovery, there's many bases to deny the approval, or to grant summary judgment. But if summary judgment is okay, if the discovery will not lead to a disputed fact. So in this case, we had the clear points that they were behind on their dues. That was an adequate basis to deny, and the deeds were never submitted for approval. The selective enforcement was addressed as it relates to the dog, and we believe we have an independent ground. The selective enforcement of the approval was not before the court, and I don't believe it's before the court now. Thank you, Your Honor.
Thank you.
Your Honor, just briefly want to address what I think is a fine legal point here. The affirmative defense of selective enforcement is not addressed to whether or not the transfer was approved. The selective enforcement is whether or not the application process was actually followed throughout the association.
Is opposing counsel correct that his client submits an affidavit in support of summary judgment that basically says your client didn't comply with the requirements of the declaration in order to pursue the process?
The affidavit submitted by them address that my client did not follow the application process. What it does not address is whether or not the application process is uniformly required.
Once he files that, saying that they didn't do what they need to under the declaration, doesn't the burden shift to your clients to at that point come forward and say, he's right, we didn't, and we don't have to because they don't enforce that policy across the board?
And we did, Your Honor, through the affirmative defense. We also did it.
To file something that raises a genuine issue of material fact rather than just a naked pleading saying that?
Well, Your Honor, the naked pleading is that they're selectively enforce it. What I'm trying to do and what I tried to get.
They responded under oath saying, basically, no, we don't. They didn't do what they're supposed to do.
I'm sorry, could you say that again?
Their position seems to be, we've addressed what we needed to by saying that these folks didn't follow the requirements of the declaration, and I think flowing from that is the argument, they didn't do what they have to. We didn't have to approve or reject. We don't get to selective enforcement because they didn't do what they were supposed to. But doesn't the burden then shift to your client to come forward with evidence to say, yes, we did comply with the requirements of the declaration, or we didn't comply with the requirements of the declaration because we don't have to, because they never enforced those terms against anybody else?
No, I don't think the burden shifts to us because the issue is whether or not the application process is actually enforced, and that was never addressed in their affidavit or anywhere in their affirmative defense. They're saying that the application was not followed. In my affirmative defense, I raised that was not, that's selectively enforced, and through the process of discovery could establish that burden was never, or that response was never addressed by the appellee in any of their affirmative defense. I mean, it's one thing to say that the application, they didn't follow the application process, but what I'm saying, the application process is never uniformly addressed. It's their burden to come back and say, no, the application process is uniformly committed, and every transfer of property is supposed to be approved by the association, and you won't find that anywhere in any of the affidavits filed by the appellee.
Well, your second affirmative defense is that counsel for Masters sent the association copies of the deeds complying with the provisions of 13.1, which I assume is the application process.
That is, yes, Your
And
Honor.
they filed an affidavit saying, no, they didn't. They didn't comply with it.
But the problem is, Your Honor, in section 13.1, the application process is not defined what the application actually is. It says that the association, that the unit owner is supposed to provide a copy of the transfer to the association, a pending transfer, and allow them to
So without
approve it.
providing supporting factual information as to what you are now contending, are you suggesting it was the trial court's responsibility to go through the declaration documents and say, oh, this must be what they mean?
No, I'm not saying that at all, Your Honor.
So how do we know you've given that argument to the trial court that you're giving to us in the absence of a transcript?
Because I didn't have the opportunity, I didn't have the chance to fully flesh out the issue in discovery and to be able to raise that. And that's why during the summary judgment hearing, I asked for additional time to conduct the discovery. I think that the case law is
You're at the end of the 5 minutes. Why don't you go ahead and conclude?
I think, Your Honor, we would just ask the court to reverse the summary judgment remand and allow the case to be tried on its merits. Thank you.
Good. Thank you, counsel. That concludes our session for this oral argument, and we are adjourned.